So moved.
If I could just make a quick
Yes.
comment. Is
You
it
may,
possible
Assembly member?
on issue 3, is it possible that we could just hold it over rather than rejecting it? It seems like it would allow them to go back and maybe amend it instead of bringing it completely back and moving them completely out of the system. Is that a reasonable consideration, or are we going to go with the rejection?
Well, we can hold it over, but I think that you're hearing that we're rejecting it, and we're going to hold it over. I don't have a problem with that. But if you don't bring something back different, it will be voted on to be rejected. Could you withdraw item number 3, and we'll vote on number 7?
Happy to. I would withdraw the motion on item 3 as it relates to issue 3.
Okay. So we are now going to be voting on issue number 7, language access. And the only thing that I would ask that we note when it talks about translation, having individuals translate, that they physically have to be a live body, not where they get on a phone and somebody translates to them, but a physically live body. Yes, do you want to address
Madam
that?
Chair, and we agree that it's absolutely preferable to have folks in person providing that translation services. But given the remote nature of many of our courts and the variety of languages that are spoken throughout our branch, we feel that there should be an opportunity to have some flexibility to address those needs, especially in those remote courts with very few languages spoken.
I hear your concerns and your flexibility, and I'm willing to move forward on that. What I would ask that you strongly consider that if you're going to have someone translate a particular language, that it's in a manner of someone that if we needed to get a hold of them, that they're not overseas or anywhere, so that someone could actually have access to them if they needed to. Bring them physically in. I mean, we've got to be. I dealt with this issue on the local on the local council, and one of the things that I kept hearing from my community, where English was not their first language, that they would prefer that they had a physical person so that they could have a conversation with them, and I heard them loud and clear. So I'm willing to vote for this with what you're asking, but I would really encourage you all to use that as a last result, because people that do not speak English as their first language, I think we're doing a disservice if we don't give them access to somebody that can speak their language.
Understood, Chair. Thank you.
Thank you. So call the roll. You know what? Having said that, could we actually, could I ask for your motion to maybe have this come back after maybe 3 years to see if it works, so for them to report out? And if there are any complaints, if it's someone on a phone.
More than welcome.
Yeah, I'm just nervous about completely taking the in-person out. So why don't we give you a try, if you're willing to amend that motion, and they can report back in 3 years and see if there are any complaints to that. I just am really nervous about not having someone in person. But if we have checks and balances, I'm good with that.
My motion is amended as presented by the chair.
Campos?
Aye.
Campos, aye. Holden? Holden, aye. Lackey?
Aye?
Lackey, aye. Rodriguez? Rodriguez, aye. Motion passes 4-0.
Thank you. Go to, we're going to go to issue 4.
Yes.
Court Innovation Grant Program.
Yes, Madam Chair. The governor's budget proposes a one-time general fund augmentation of $30 million in support of a new court innovations grant program intended to identify and promote improvements, efficiencies, and access to justice. Given that the trial courts still are dealing with $250 million of ongoing reductions, a workload gap of almost $400 million between what is needed to do the work of the courts and what is funded, the opportunity to invest in innovation and look to provide new and innovative access to the courts we think is extremely important, and we really appreciate the governor's proposal to do so. It's their ongoing effort for the branch to innovate and become efficient, and we look forward to working with the committee and providing additional information. And so we appreciate the recommendation in terms of additional information. We may not be able to get all of it because there is a prospective aspect to the proposal, but we are excited to work with you to get funding in advance of any future recessions in which the courts can be better prepared to deal with any economic downturn.
Okay, thank you. LAO, do you have any?
Yes, we recommend that the legislature withhold action on the governor's proposal pending additional information from the administration and the judicial branch. We do believe that the proposal has merit, as innovation and efficiency projects can ultimately generate savings or improve access to trial court or appellate court services. However, the proposal provides very little information on what programs and services would be funded, why they're needed, how much is needed to fund them, and how they compare to previously tested projects, and what performance measures would be used to measure program effectiveness. This lack of key information generally reflects the fact that Judicial Council would have significant discretion over the types of programs and services that would receive funding. For example, the proposal contains little guidance on how the grants are to be awarded, thereby allowing Judicial Council to decide whether certain types of applicants have priority and what metrics would be used to evaluate the applicants. The lack of detail also makes it difficult for the legislature to determine whether the governor's proposal is the appropriate level of funding for those projects that are aligned with legislative priorities and the extent to which they could be duplicated across the state. Additionally, because the proposal lacks details that would specify and standardize how performance metrics would be measured, the legislature may have difficulty comparing the funded programs and services to determine which provide the greatest benefit to courts or members of the public. In light of all of these concerns, we recommend that the legislature withhold action pending additional information. Specifically, we recommend that the legislature require reporting on which specific programs and services would be funded, why they are needed, how much is needed to support each program and service, which courts would pilot them, what specific performance outcomes would be measured to determine program effectiveness, and finally, how the judicial branch would determine whether they can be implemented across the state. Based on this information, the legislature would be able to determine which programs and services it would like to fund on a pilot basis. To the extent that this information is not provided, we do recommend rejecting the proposal.
Finance.
Thank you. Tiffany Garcia, Department of Finance. We support the governor's budget, and we believe this funding will encourage the courts to look at existing operations and find innovative and more efficient ways of doing business. And I'd also like to point out that we do have provisional language that would require the courts participating in these programs to describe how the funds will be used to support the development of innovative programs and practices that will be sustainable after the grant period. And there also is an additional reporting requirement that the Judicial Council will report to both you and the Department of Finance on the status of these programs in September 30, 2017.
Any comments from my colleagues?
Yeah.
Oh, yes, Mr. Rodriguez.
They're kind of in general, do you know what type of projects would be envisioned under this program? And then for two, couldn't we use this money for raises for some of these folks who haven't had a raise in close to 10 years?
And we appreciate and support the need for additional funding for staff. However, the proposal is for one-time money, and so raises are an ongoing cost. So from that perspective, the governor's proposal isn't an ongoing cost. And in terms of the types of areas that we look at, definitely innovation. Our branch strategic plan talks about digital courts and connecting courts across the state. And there's currently multiple platforms that are being implemented. How can the state benefit from information? one aspect of that. There's also operational issues in terms of increasing access, reducing wait times, online services, changing the way in which the court operates. So those are the kinds of concepts that have been already done in small scale, in unique areas, family law, one-day marriage, divorce in Sacramento. Those are the kinds of things that have been done. We're very interested to see how it is that we can expand those and really generate some savings so that these courts have the resources to look at providing additional raises to their employees coming out of being more operationally efficient.
Any other questions? Public comment on this item?
Good afternoon, Michelle Castro with the Service Employees International Union. We agree with everything that the LAO said. We have a concern about a lack of guidance. There's a lot of questions we have on this issue. Our belief is any reforms, innovations ought to include the input and participation of the employees who are actually doing the jobs and who can talk about things about what kinds of technology actually enhance their jobs, make their jobs go quicker and easier. We're concerned that a lot of times the courts talk about innovation that just gets rid of people. Let's put in electronic recording and get rid of court reporters. We know that's highly flawed. Let's put in kiosks that the public doesn't like and get rid of clerks. We believe and we know that our employees have experience on these jobs and that there is technology that makes their jobs go better and faster. But absence of guidance and participation of employees, we have a lot of concerns about this and agree with the LAO. Thank you.
Next speaker.
Good afternoon. My name is Barbara Kaufman. I'm glad the Judicial Council mentioned the strategic plan. The number one priority of the branch's judicial strategic plan is fairness. I haven't heard a single proposal for any measure of fairness. In fact, the legislator provided Government Code Section 77001.5 requiring the Judicial Council to measure and report on fairness and respect for litigants. They have refused to do so. They are not complying with the mandate, and yet they're here asking for more money for innovative programs. We've heard today judicial accountability is the number one concern of the public. The Judicial Council was told in 2005 by their own experts that judicial accountability is the number one unmet expectation of the public. The Judicial Council should be focusing on judicial accountability. There is none. We provided you with a summary of how every single remedy is closed to the public. There's no protection for the public.
Thank you. Next speaker.
Melvina Martin, I am against, just like Barbara Kaufman. If they're going to do this as a one-time money, well, let's put it to good use because we all know family courts do electronic recordings, which is denied to the public, and those litigants who don't have attorneys to get those electronic recordings. And this one-time money needs to go to domestic violence, child abuse, and family law to have those real programs, to real court reporters, to have actually attorneys afforded to those disabled and socioeconomic litigants who can't afford attorneys, where those who do have money can. So please put it to good use for the fairness and equity and the respect for litigants and children, and not for a corrupt
Thank you.
system already that's
you.
broken.
Next speaker, please.
Hi, my name is Deborah Pearson, and I work for the courts in Alameda County. And I agree with the LAO on this. There's words in here like, first of all, who's going to decide on these grants? And deciding on grants do those go to courts that are favored maybe over others? I mean, we have a funding system with the courts right now where some are donor courts and some are not. I happen to come from a court that is a donor court. You want to talk about raises? My employees take home the same amount that they did in 2010. So when you talk about money for grants, I want to know, it could be used for funding to all 58 counties, distributed on an equal basis. So I want to thank you for your time. I disagree that this shouldn't be done. I think that leaves so much for interpretation that shouldn't be there. Sort of like affordable housing. What's affordable? What's innovative?
Thank you.
Joshua Golka with the American Federation of State, County, and Municipal Employees. We share the concerns of SEIU California as outlined by Ms. Castro and encourage that court staff be engaged in this process as participants. Thank you.
Next speaker.
Hi, Kathleen Russell, Center for Judicial Excellence. Also agree with the LAO assessment. And just want to point out, Barbara mentioned this, but the Judicial Council is required by the legislature to give a report to you every year in Government Code Section 77001.5. They're supposed to be tracking access to justice and integrity of court records issues, and they claim they have no money to do so. So this is something that could be directed toward that. Thank you.
Thank you. Next speaker.
Thank you. Brian McCabe, I'm the presiding judge of the Merced Superior Court. I'm also the chair of the state's presiding judges advisory committee, and as such, I am an advisory member to the Judicial Council. I disagree with the LAO's position on this. This is one-time money. We would agree if there were ongoing monies that were offered by the governor for employees. I think the trial courts would welcome that. But that's not the case here. It's one-time monies where the governor's put a carrot before us and asking us, using money, a great incentive, to come up with innovations. Look at those after a year, and if they can be applied on a statewide basis, great. Many of those may produce savings in which the courts can use those in other areas. So we would ask you to deviate from the LAO position. Thank you.
Hello, Jake Chatters, the Executive Officer for the Placer County Superior Court. Here to support the governor's proposal. We look forward to working with your committee and the LAO's office and further defining the options available to us for this grant program. I would suggest we may want to look towards the Recidivism Reduction Fund grant program that was put into place this year as a way to administer the program and identify successful programs to implement. I'd also like to suggest that as an example, in our court, in 2009, we had 186 employees. Today, we have just under 110. Looking for ways to innovate through technology is not about eliminating additional staff positions. It's about helping our staff deal with the workload they have today. It's about giving judges the information they need to make good decisions. And it's about making the public's access to their justice system more convenient, easier, and with greater information. So we appreciate your consideration. Thank you.
Next speaker.
Hi, my name is Fatima Katimbasi. Basically, the United States Justice Department just issued out a memorandum to give the states, local, and tribal jurisdictions $2.5 million competitive grants to basically will help the stakeholders and to change the needed system as far as the equal access to justice and guarantee that everyone who is indigent in every state who is going to receive equal access. Thank you very much.
Thank you. We're going to hold this item open, so thank you and all the public. We know that there are several of you who have traveled far to make public comment, and before we start losing individuals from this body, I want to go to file item 5, Equal Access Fund, and I will have Jesse talk. And then we're going to go to public comment because I know that the public also traveled far, and I want to make sure that they're heard as well. So, Jesse, please.
Thank you very much, Madam Chairwoman.
I can move.
No, that's...
Oh, you're fine. Go ahead, Jesse.
Thank you. Madam Chairwoman, if it is acceptable, I would like to turn over 1 minute of my time to Selena Copeland, who's here from the Legal Aid Association of California, to provide some statewide numbers and some statewide comments for mine. Is that acceptable?
That's acceptable.
Thank you. Good afternoon. As Jesse said, I'm Selena Copeland, the Executive Director of the Legal Aid Association of California, and we represent the interest of the roughly 100 nonprofits funded throughout the state through the Equal Access Fund.
And I want to just briefly give a picture of the statewide need for increased funding for legal aid. Throughout California, you can qualify for legal aid whether you are income-based at 125% of poverty or less, or if you are a senior over age 60, or if you are a person with a disability. And those populations are growing throughout California. Since the Equal Access Fund was created in 1999 with a $10 million in general funds, the amount has actually increased. Our population age 60 and over have gone from 4.5 million to over 7 million, and people at 125% of poverty have gone from 6.3 to over 8 million people. So the eligible population is a graph like this, and the funding has remained flat for Equal Access Fund and has actually decreased for another core source of funding, the interest on lawyer trust account. So I'm going to provide information via a bunch of charts to show the amount of dollars per poor person here in California spent on legal aid. We've gone from $2.5 to nearly $5, and we're back down to below $2 per person who's eligible for free legal aid. So I'm happy to share that information with you for later. And I also have a lot of stories from programs who said exactly what they would do with increased funding, whether it's hiring a social worker to be able to work in Santa Barbara County and join the lawyer team to provide wraparound services and other appropriate services, or whether it's being able to help seniors higher up on representation rather than giving self-help resources. They'll be actually able to help represent them through court. So I'm again happy to give it to you
Thank
later.
you. So we're going to be taking this up another day. We're not taking a vote on this particular item. Is there any public comment on this item?
Sorry, is there still an opportunity for me to present?
Let me listen to the public comment. I apologize.
That's okay. I understand it's
I'm
illegal.
going to lose my quorum in a few minutes.
Thank you very much. I'll be brief. My name is Ron Roby. I'm a justice of the Court of Appeal in Sacramento in the 3rd District. I'm a former chair of the California Commission on Access to Justice, which is a 27-member commission, broadly based appointees from the Speaker, the Governor, the President Pro Tem of the Senate, and we strongly support Equal Access Fund and increases in its funding. One of the functions of the Commission on Access to Justice is to ensure access, and the best way to do it is to provide lawyers for people who can't afford it. So we urge you to increase the Equal Access Fund above where it is today. Thank you.
Next speaker.
Barbara Kaufman, I do support increased funding. The vast majority of litigants in California are self-represented. The self-help centers are crucial. They need all the help they can get. Thank you.
Thank you.
Gary Smith. I'm the Executive Director of Legal Services in Northern California. I just want to make one brief point in support of a proposed increase to the Equal Access Fund. Every year, this legislature enacts dozens of important statutes and programs designed to benefit the poorest residents of California. Those laws and programs will become empty promises if they're not enforced. The legal aid community, the statewide legal aid community, is the enforcement mechanism for all of the really great stuff that this body enacts on behalf of poor people.
Thank you.
Good afternoon, Madam and committee members. My name is Magda Perez. I'm the Executive Director of California Rural Legal Assistance Foundation in support of increase of equal access funds. Over the years, we've had the privilege of representing farm workers in a number of unpaid wage cases, but over the last couple of years, we've seen an increase in the need for representation of farm worker women who have been sexually harassed in the fields. And so these communities continue to be the most isolated due to transportation and language issues. And so more equal access funds would allow us to provide representation to those communities in greatest need of representation. Thank you.
Thank you.
Hello, my name is Sydney Reyes with the California Partnership to End Domestic Violence, and we are in support of the Equal Access Fund. We know that legal aid organizations help survivors and their families stay safe and help connect them with benefits. Thank you.
Thank you.
Good afternoon. I'm Liz Guillen with Public Advocates. We support the proposal to increase the Equal Access Fund. Our educational equity project uses these funds to help us provide assistance and support to parents and students whose voices are so essential in the educational equity work that must be done in our school system. Thank you.
Thank you.
Evelyn Abu Hassan with Disability Rights California. We're a cross-disability rights organization. We are a recipient of the Equal Access Funds. Those funds help us to help people with disabilities stay in their own homes, get benefits, and be independent. So we're in strong support.
Thank you.
Thank you.
Madam Chair and members, Kevin Baker, American Civil Liberties Union of California. We are not a recipient of these funds, but we are very mindful of how they support public safety and the rule of law in California. These are poor people who are fighting in domestic violence issues, elders, veterans, and we very much would love your support. Thank you.
Thank you. Next speaker.
Hi, Kathleen Russell, Center for Judicial Excellence. We also support increasing this fund, but wish that the majority of civil legal aid groups in the state would handle and deal with the family law cases because so many of them don't have the resources to do so, and that, as you heard earlier, is a big problem. Thanks.
Thank you.
Angelique Barboa, Merced County. As an improper, I had difficulty where I could not go into the court system and get that assistance because the fact that the attorney that was working there, it was against me. So therefore, it would have been nice if I have more access to the Equal Access Fund, because the fact that in my county we didn't have enough people to assist, and that was really hurtful on me, because the fact that I had that initiative to go forth, then I wouldn't probably maybe have more help. Then I probably had help with my child. So it's important. Thank you very much.
Thank you.
Hi, Bob Saunders again, Sacramento. I believe that legal aid and the Public Defender's Office should get just about all the money that they need. They are the truly defenders of the people, not like the District Attorney's Office. The other part about it is, and it's unbelievable that in a family court that our most precious children, the precious thing in life, children, have nobody representing them that way, or a parent, that almost 85% of people have to represent themselves because they have no money to represent themselves. How important is family court?
Thank you for your time.
If you can't get a lawyer.
Thank you. Our last speaker on this item.
Melvina Martin. I am for it, but also at the same time that I would like these organizations to not put blinders on, because I have come across many nonprofit organizations, and I mean numerous organizations, that state these are our missions, these are our goals. And when I have come to these organizations, I have been told, we cannot help you, you need to leave. So I would like you to get the funds, but I would like you to treat everyone the same, no matter who you are and who you've investigated. And that's what you need to do with those funds and go all the way forward.
Thank you.
Okay.
Okay. We're not taking an action item on a vote on this particular item. It will be pushed over. But my colleague, Mr. Holden, Assemblyman Holden, would like to make a comment on this item.
No, I thank you, Madam Chair. I know we're not taking action on this item today, but I do think it's important to make a comment in relationship to the testimony that we've heard, not just on this item, but also on some of the other items. And this does kind of go to the heart of equity and fairness, especially for those communities that are very vulnerable and disadvantaged through the legal system. And so we appreciate the governor's proposal. I think that as we go through this process, as it makes its way, when we make our way through the process, I think we really need to dig as hard as we can to try to find additional resources to support so many Californians who fall into the cracks, and this is a way to kind of create better equal access, and that's an important charge for us.
Thank you. So I am going to go to public testimony for item 6. As you all know, thank you, panel, very much. Thank you. As you all know from past votes, the Assembly supported this program, which I'm talking about, Dependency Council. In the interest of time, I've read the report. I'm sure my colleagues have read the report, and where the different individuals, where the different agencies are at. I'm going to go to public comment at this time on item number 6. That's dependency. You know that we've been supportive. Last year we supported $33 million on this particular item. And so now I'm going to be going to public comment. State your name and line up, please.
Okay, my name is Fatima Katimbasi once again, and basically I have a current case right now in juvenile dependency. I have teenage daughters. My children were removed out of my care, not for abuse or neglect. It was for their out of control behavior, and they are afforded to be in foster care, and one of them is currently in the Sacramento Children's Receiving Home. Currently, my daughter is trafficked by the system, which was initially designed to protect the children. How can a case be brought before a judge who adjudicates a dependency case, and also sits on the committee of the Children's Law Center? That's happened in my case 3 times. It seems to me that this is a double-dipping issue, conflict of interest, failed to disclose, and families are subjected to unnecessary litigation. Currently, I have a 6-year-old in my care, and I have she's just made 18, and then a 17-year-old that's in foster care. One has been AWOLing, been running away. So I believe that the dependency attorneys, they are needed, but 9 times out of 10, they're for the children to put them in the situation into foster care. They're not really there to. Okay. Thank you.
Thank you. So everyone has a minute. Thank you.
I'm sorry that you've all run out of time before this issue has come before you. I'm Geraldine Borak. I'm a judge in Sacramento County. I've sat in dependency for 6 years. I sat in family law for 5 years. For the last 10 years, I've co-chaired the advisory committee to the Judicial Council on Family and Juvenile Law. And I currently co-chair the subcommittee that is looking at the allocation method for distributing the funds that we do get from you for dependency counsel. I'd be happy to answer any questions that you may have about the role of dependency counsel in our courts. However, what I want you to know is that the Judicial Council is committed to providing in our diverse state system, a more uniform for procedures and performance in providing access to justice. Pardon me? I can't finish in 10 seconds. I'll write it out for you. Thank you.
And we'll read that as well as we move forward before we vote on the item in the next session.
Hi, Leslie Heimov again from Children's Law Center of California. CLC of California is in the unique position of being both a donor county and a recipient county. In Sacramento, we're a donor. In Los Angeles, we're a recipient county. And from both of those perspectives, the increased funding is essential for us to be able to represent our clients effectively. We have seen some benefit from the initial $11 million increase that was granted last year. But what it is like for us is that the pot is no longer boiling over, but it's still boiling. Our lawyers still can't do everything that they need to do or that they would like to do in order to really provide the best possible representation to the children that are before the court, because the state made a determination that they needed to participate in that system. These are children who, through no fault of their own, have to be involved in this system, and it's our duty as a legislative body, as the governor's office, and as citizens to give them the best representation possible. I also want to note very quickly that one of our our former clients, who is now working as a peer advocate for the Expectant and Parenting Youth Project in Sacramento County, was here to testify today. Unfortunately, she had to leave early to go coach her 6-year-old's t-ball team, but did want the court to know how important her attorney was to her success in exiting the foster care system as a success story.
Thank you. We had a lengthy first item. Next speaker.
Hi, good afternoon. My name is Andrew Kane. I am with Legal Advocates for Children and Youth out of San Jose. Our office represents the kids out there. I am also with Roger Chan from East Bay Children's Law Offices in Alameda County and Hillary Cushins of Dependency Advocacy Center in Santa Clara County. Rather than each of us make a brief comment about why we feel this is an important item, we're going to turn it over to Dave Schuster. He's a parent advocate out of Santa Clara County and was a parent who successfully navigated the system. He can speak directly to the importance of this issue.
Good afternoon. I'll make this brief. My name is Dave Schuster. In 2009, my wife and I were arrested on drug charges and went back to jail. We clearly had a drug addiction that spanned over 17 years with very, very short periods of sobriety. CPS would move our children that day and placed into foster care. In our drug program, we were able to have a personal relationship with our attorneys that helped guide us through the process. They were able to spend the time needed to help us feel worthy of getting our children back and teach us to be accountable for our actions. My wife and I realized what helped us be successful, and it was the programs available, the guidance of our attorneys, and our own hard work. I ask you, please, give other families the opportunities that we had. By supporting our attorneys, we're giving children back their healthy parents. And my wife and I just celebrated 7 years clean and sober this weekend.
Congratulations. Next speaker.
Hello, I'm Marissa Shea on behalf of the California Court-Appointed Special Advocates Association. I just wanted to echo the sentiments of CLC and state our support on this matter. Thank you for your time.
Thank you. Next speaker.
Nicole Wertelman on behalf of the Ventura County Board of Supervisors and Orange County Board of Supervisors. We are also in very strong support of additional funding for Dependency Council.
Thank you.
I'm Julie Tron. I'm the Director of the Court Appointment Programs in San Francisco for the Bar Association, and as such, I oversee both court appointments in dependency cases as well as in our criminal and delinquency courts when there's a conflict of interest. I can tell you that we spend more dollars representing an individual in a trial on a DUI case in a misdemeanor than we are able to afford in our family courts on dependency cases. And yet the consequences are lifelong. Let me put a face on the families in San Francisco. We are 10 times the number of African American families in our dependency courts than we are in our general population. We seem to be understanding that over-incarceration in this state has led to the destruction of African American families in this state. And I don't understand why we are not seeing the damage that we will do and continue to do in our dependency courts if we do not find additional funding. We are considered a donor court. We don't have a penny to donate. There's no county that does. The ACLU is telling us how completely underfunded we are. So I will submit some additional documentation to you in writing because it's really difficult to summarize this great need in such a short period of time.
We'd look forward to that documentation. Next speaker, please.
Good afternoon. My name is Zamina Abrams. I oversee operations for the Unified Family Court in San Francisco. I agree with every of the speaker that presented in front of you. We do need more money for this item. There's access to justice that's most important of all, and it plays a big role when there are individuals who need extra help, and they're the attorneys that advocate for these people that give them the voice that they need to get the help that they need to reunify the families, to keep the family united. So thank you for your time.
Thank you. Our last speaker.
Hi, Kathleen Russell, Center for Judicial Excellence. We agree with the committee analysis that California's abused and neglected children deserve better, as does the California Protective Parents Association and Attorney Barbara Kaufman. Thank you.
Madam Chair,
Yes.
this issue is a priority to the Chief, as identified in her State of the Judiciary and part of our budget priorities that we presented to you.
And it's a priority for, I think, the panel as well.
Indeed.
Hopefully. First of all, thank you for being patient. I know we had a lengthy first item, and we will not be voting on this particular item right now, but I thought it was important for us to be able to hear the public comment. We had a full house today, so there were a lot of good comments and concerns. Are there any questions from members? No. We will be holding issue item 8 over to a later date. Please check the Assembly Daily File for details, but I think we got to the essence of what we needed to get through today. Thank you for being patient and continuing to be a part of the dialogue. This meeting is adjourned. Thank you.